Hey, what's up, everybody? So, sometime back, actually a couple of days ago, I did a collaboration with Trent Cochran. His channel is called Opinionated, and basically, we had a collaboration. We were talking about what questions would be allowed to be asked against Lanita Carter, right? Or other words, we were talking about Lanita Carter, and we were talking about the types of questions that would be allowed when the R. Kelly lawyers cross-examine her, right? So to me, I thought it was a very interesting conversation. And when I did the collaboration, I did it with the mindset that, he was a very good content creator and he was really good with, looking at the law. And this is like the first time I've ever really come across someone who looks at the law and he looks at the statutes and case law and so on and so forth. So I thought we could have a really good collaboration. But I was actually kind of surprised to see how he labeled the video. He basically labeled the video Trent Cochran, defendant versus the non-lawyer, the state. Now, I guess I shouldn't be surprised because basically, in order to get attention to your channel, to get attention to your YouTube videos, you either have to label your stuff kind of, I guess, controversial in a controversy sort of way, or you have to post controversial material. That's not surprising, right? So I guess I really shouldn't have been that surprised. I just don't see it that way because I didn't really do the collaboration to debate with them, even though I was just looking at it from a different perspective. But hey, I guess he's free to name it whatever he wants to name it. My video, basically, I'm not sure what I'm going to name it, but I'm not going to give it a name like that because that's not what it was. In my opinion, and no offense to the gentleman, it's kind of mislabeled it, but he's doing that to get attention. And I was also surprised to see some of the comments people basically made, and they're saying like, I don't know who Lisa Chris is, but she's saying it sounds like he want to be a prosecutor, the non-lawyer I'm talking about, right? So look, what I do when I make videos, I try to have a balanced approach. I try to have a balanced approach. You're always going to have some sort of bias in your videos, and you're probably going to be biased to the person you want to win the case. That's always going to happen, right? But I try to balance things out a little bit. And my whole thing is that I think there's certain questions you're not going to be able to ask Lanita Carter. But you know what? That's neither here nor there. I thought the video was pretty entertaining, and I actually kind of came out in a way I typically don't come out, and I talk in a way I typically don't talk. So you might, if you come to my channel on a regular basis, you might find this interesting. So here's a video. Please check it out and like, share, and subscribe. And again, thanks for watching. So you actually had some things on your channel that I just found it really interesting. I found your channel now. So I like your channel, and you had some things on your channel that I thought was really interesting. So I was like, man, so when you actually hit me up on my page, I forget what video you saw on my page, and you hit me up and you was like, let's do a live so we can talk about this. And I was like, cool, but I really want to talk about this video you have on your channel, Lanita Carter. Let me go ahead and share my screen here really fast. All right, share screen. Okay. Screen sharing is easy with 2 monitors. Okay, let's see what screen is going to share. I don't know what's going to happen here. Share screen. Okay, yeah, it gives me the chance to pick the screen, so we good, right? Okay, you can see my screen. Okay, awesome. Yeah. So now the video I saw was the video where you were talking about questioning Lanita Carter. And when I initially saw the video, I was like, this dude is cold. I was like, this dude is cold. But then later on, I actually was doing some reading, and where's that video at? Is it list name Lanita Carter?
Keep going down. It would have been before all of that.
Oh yeah.
Keep going down. All right.
questioning the witness or something
There
like
you
that.
go right there. There you go right there.
Which one?
On your far right. Third one up on your far right. Go to the far right. Third one up.
Third one up, 2, 3. There it is. Yeah. So I just thought this was a cold video. Let me see.
Yeah. Yeah, that was in the work parking lot. It was raining like a motherfucker.
So I thought this was cold, but after doing some reading, because I was reading up on some other things, because I do a lot of videos too, and when I do my videos, I try to base it based off the law or the statute or whatever's going on. So one of the things I noticed is that a lot of stuff that you said in the video, although was like really to the point and it was kind of ingenious, because I think you were saying like, look at this person's character. And based on the person's character, you can basically determine whether or not the person is basically full of it or if it's just a money grab. And you're right. I mean, I agree with that 100%. If you look at a person's backstory, you look at their history, and they've been doing dirt all up until the point they filed this lawsuit against, this man, chances are that it's basically bogus. But there's one problem with all that. There's one problem with all that. The problem is I'm gonna talk about this from the standpoint. Are you East St. Louis or St. Louis?
St. Louis, man. St. Louis, Missouri. East St. Louis is Illinois.
So you in Illinois?
No, I'm in Missouri. That's what I'm saying. St. Louis, Missouri.
Okay, because I know you go across that bridge.
Yeah. That's where I go to the strip club at.
Right. So let me tell you something. I went to, where did I go?
Pink Slip?
Huh?
Went to the Pink Slip?
I don't know what it was, man. It took me because I came down there to play some poker. Because I'm in Chicago, so I play poker at the Horseshoe on a regular basis. I was like, let me change this game up because people in Chicago, not Chicago, but in Indiana, they really don't like me. And it's like, they run game on you a lot. It's like a lot of times you just need to go to someplace fresh and just, have a fresh start. So I was like, let me go to St. Louis, got off the train to Lumiere's downtown. I played poker and I think I won like $1,000. I was like, well, fuck it. Let me go to the strip club. And then I went across the bridge and I went to the strip club, but I can't remember which one it was. But
what the outside looked like, man. I'm very, very, very in activities, goddammit. All right.
All I know, it was like a
in that motherfucking period. Damn it. Me on the first name basis. Me.
I couldn't even tell. All I know, it was just like a huge open area. I'll get the name for you later. But anyway, what's up? Because they said it was the biggest one with most of the black people in there. Because they said one of them had just closed. They said one of them just lost. Yeah, that's what it was.
They closed for about 2. Pink's have been closed for about 2 years now.
Right. So this would have been like 4 months ago. 4 months ago.
Yeah, nigga, that was bottoms up because everything else in Brooklyn is closed.
Yeah, and the thing I like about it is that it was really just a club, even though it's a strip club, but the way it's actually done is really just a club with strippers in it. That's the way I feel about it. It wasn't like the traditional strip club where you basically come there and you basically just there for the ladies and the ladies just control the entire show. It was really just a club where people were just drinking. Yeah, there was strippers there, but it just felt more like a club. And I ain't gonna lie.
I could take you to a place. I could take you to a place, goddamn
it. I'm not gonna lie to you, man. I love going to strip clubs, but I hate giving away my money. So
yeah. Hey, goddamn it. Listen, you gotta be a blessing to somebody so it could be a blessing to you, goddamn. Fuck what you talking about, goddamn. Listen. I'm making this motherfucker on quarantine deprived, goddamn.
But anyway, let me get back on point. Let me get back on point, man. So you're not East St. Louis, correct?
No, I'm not, bro. I'm
All
from.
right. So basically, East St. Louis is Illinois. I never really knew that. You know, for those that are basically joining or whatever, East St. Louis is Illinois, basically. So basically, there are rules to the game. So if you want to bring a person's history into court and you want to question, because I think your video, the way you went about the video, you were talking about how you would question Lanita Carter if you was a lawyer and how you would bring up her past. And all of that is fine and dandy when it comes down to dealing with people basically on the street. But when it comes down to court, you actually can't do that. And I'm going to show you why. Evidence of character. And this tripped me out because, like I said, I would think if a dude was just bogo, if a person was just, you know, dirty and they known for, you know, doing people dirty, that you can just bring up their character. Methods of, actually, I didn't even read this. Evidence of character. Okay, so methods of proving character, reputation, or opinion in all cases in which evidence of character or trait of a character of a person is admissible, proof may be made by testimony as to reputations or by testimony in form of an opinion. So basically, you could come out, like if you knew the witness or you knew the defendant or the person that filed the case, you can come out and speak on that person's character and reputation, or, you know, somebody can basically, that person come out and give testimony, right?
What
So
rule? What
this
rule
is
is this?
this is Illinois now. So here's the thing: it's going to be different from state to state. So
But I'm just saying, what rule is this or whatever? Because we having a law discussion, so I got to see what you do. Because, you know, if we got two opposing arguments, then I got to be able to see what you see. Because
I'm sharing my screen. That's why I'm sharing my screen now. So basically, what I'm trying to get to is that certain things are not admissible in court. You can't bring certain character evidence into court. So, for example, if I was actually trying to find this. I wish I'd have been a little bit more prepared before we had this live. But basically, let's say you just known as a horrible person, and you basically, I take you to court for stealing my car, right? And basically, the only character evidence that I could use in that specific incident is any character evidence I have where you're stealing cars. But the character evidence where you running around busting people's heads, stabbing people, shooting people, that wouldn't be admissible in court. So when we coming back to that Lanita Carter video, if you try to bring any evidence into court that doesn't have anything to do with that specific situation, then it wouldn't be admissible. You see what I'm saying?
Oh, because right here it says evidence of a character witness. So if you're talking about the character of the person,
that's right,
then everything is admissible. So therefore,
it's not. That's the point I'm trying to make. You have to here it is. Rule 404, character evidence not admissible to prove conduct, exceptions, and other crimes, right? So evidence of a person's character or trait or character is not admissible for the purpose of proving action in conformity therewithin on a particular occasion, except. So basically saying that you just can't generally bring a person's character into court and use that as evidence, except in a criminal case, evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same, right? So pertinent meaning something specific. That's generally what is meaning. So if I look up the definition of pertinent, relevant or applicable to a particular matter, right? So basically, the only evidence that you can bring into court when it comes down to a person's character is the character evidence that relates to that specific incident. So going back to Lanita Carter, she basically has a trashy history. And believe me, I'm not here to support Lanita Carter, but this just blew my mind when I read it, because I saw your video and I was like, damn, that dude is cold. I was like, this is a cold video, and everything you made in that video made sense. But if you were basically defending R. Kelly and you tried to bring all that stuff up, this would have stopped you dead in your and this would have stopped you dead in your tracks. Supreme Court Rule 404 A and A1, right? Basically, the only evidence that you can bring about Lanita's character is the stand-up poetry readings where she says she's addicted to giving, you know what. But anything above and beyond that, you wouldn't be able to bring. Are you still there? It looked like you dropped out. Testing, 1, 2, 3.
Yeah, I'm back.
Yeah, ain't that crazy?
So hold on, go back. I missed what you're saying.
So, okay, all right. So let me just read it again. Evidence of a person's character or trait of character is not admissible for the purpose of proving action and conformity therein on a particular occasion, except. So basically, this line is telling you that a person's character cannot be brought into court except under specific conditions. In a criminal case, evidence of a pertinent trait or character offered by an accused or by prosecution to rebut the same, right? So basically, you can only bring it, they say pertinent, but specific is probably a better word, because like I said, when we look up the word pertinent, I'm about to switch over to the definition of pertinent. 1 second.
Now let me rebut what you're saying right now.
Go ahead.
There are prohibited uses and permitted uses, right? And so you have to tell me what specific evidence that you're talking about. But when we go to the Cornell Law Library, it says evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or a lack of accident. So
you're looking at evidence in general.
No, I'm looking at this specific rule that you were talking about.
It's okay. Share your screen. I'm gonna stop sharing my screen. Share your screen. 1 second.
I'm talking about Rule 404, character evidence or crimes. So I'm actually on another computer.
Oh, you're on another computer? Okay.
Hold on.
Where you said I can just bring it up. I'll share my screen.
No,
just send me the link. Oh, you got it. Go ahead.
I got it. All right. So shit. Okay, this is the screen that we on. All right. So let's go right here. So. All right. So when we go right here, this is Rule 404, character evidence, crimes, or acts. Then when we go here,
what state is this though? Is this federal or is this?
This is just law. This ain't. This
no, it don't work like that. Okay, so.
All right, let's go. Let's go to.
No, we're fine. I just want to know what the context is. Scroll all the way up. Scroll all the way up.
There we go.
All the way up. All the way up. This is federal. So federal is probably a good context. Go ahead.
Now,
prohibited use evidence of a person's character or character trait is not. Hold on. Read the first line. Read the first line.
Prohibited use of evidence of a person's character or character trait is not admissible to prove a particular occasion, that person in accordance with the character or trait.
Right. So basically, they're saying the same thing. Generally, a person. Hold on. Generally, go ahead.
No. So right now, what this is to me, it says a person. It said the key point to this is it said on a particular occasion. That means that if it happened one time.
No, that's not what that means. Let me read that. Hold on a second. Let me read that. That's not what that means. Evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character trait. Okay, no, I got you. You're right. Go ahead. Keep
Right. So what I bought out. So let's stop it. Let's slow this down right now.
Mm-hmm.
I didn't bring out an isolated incident, which would be that particular occasion. I brought out a history, starting with the fact that you have four different husbands. Every relationship that you was in, you profited off of every guy that you was with. That's not an isolated incident or a particular occasion. That is an expanded body of work.
Okay.
That's an expanded history, right? So that's character. So when we're talking about character evidence, that goes to speak to your character. What the heart of this law is saying is that you can't pick one isolated time that a person fucked up and say that this is who that person is. But when you look at the expansive history of, you got 5 different kids, 4 different daddies, you have a pattern of you come with Susan Lokins, a Lakeshore Drive, or you from Chicago.
Right.
So y'all know y'all street with the top lawyers, right? I'm going to say Lakeshore Drive or whatever because I'm just St. Louis. I don't know. But you can't be having a legal aid clinic as representing you in a divorce case, that basically a free legal team, and then you come with a Lakeshore Ave lawyer to go and sue R. Kelly, and then you went to a grand jury, you went through this process, you went through a whole process. Shauna Boylicker pointed you over to Susan Logan. Susan Logan's pointed you to, no, I'm sorry. You came with Michael Mannis. You went to the grand jury. You left the grand jury. They pointed you to Susan Logan's. Susan Logan said that I can't handle this. Then you went to David Dre Pritchard. All 3 of these people are medical malpractice doctors. Right. So why did you go to the wrong doctor in this case to even argue this type of thing? You just went to any type of lawyer, but you didn't go to the right type of lawyer. So, and then you see a pattern or whatever of when she was going through the process of suing R. Kelly, she got $650,000 as a settlement, as basically go away money. However, during this same time, she filed as an indignant person. So if you file as an indignant person, indignant means that I am not able to be above the threshold. The threshold at that time was 18.
It's also called informer propis or something like that.
Right.
Hold on a second. Right. I'm agreeing with your character evidence. What I'm curious about is what would be admitted into the courtroom. That's the issue at hand, because it depends on what court we're talking about. Because you're looking at the federal statute, which I like, but you just saw the Illinois statute. The Illinois statute reads differently, right? So in Illinois, certain evidence wouldn't be allowed into the courtroom. But let's continue reading this federal statute. Go ahead.
Okay, so when we go right here, this is basically right here. Then we go on exceptions for a defendant or victim of a criminal case.
Right.
The following sections apply in a criminal case. A defendant may offer evidence if the evidence pertinent trait, aka character trait, or if the evidence is admitted, the prosecutor may offer evidence to rebut it.
So here we go. We're back at that word again, pertinent trait. So and that's what kind of caught me up, because I believe what we're going to find in this is the same thing we found in the Illinois law. You can only bring relevant evidence into the argument. So if all that other stuff that you were saying, where she profited off her relationships and she basically screwed everyone over, it wouldn't be pertinent and it wouldn't be allowed into under the rules of evidence, a character evidence. It wouldn't be allowed. But just keep reading. I want to.
Well, let's stay right there before we go on.
Okay.
Because basically, right then, if we throw everything else out, we could take 2 isolated incidents. We could take 2003 and we could take 2009. In order to take 2003 and take 2009, we have to bring in 2004 and we have to bring in 2007 and 2008, because this is very pertinent because the prosecution is going to argue that he paid it out, that he paid out money, therefore he is somehow guilty, or he reasonably should have had some guilt, because the statute is not just are you guilty, but are you reasonably guilty? And so when you go in to say that this person was below the poverty threshold, which means you made less than $18,400, but all of a sudden you show up with an attorney that costs $1,200 an hour, that's problematic. And
not really. No, that's not. No,
bro.
Because some lawyers.
At this point, we need a judge. At this point, we need a judge, because I'm saying that it is. You saying that it's not. I'm going to argue. It's not going. We're going to argue both.
Let me say why it's not. That is not problematic. It may be pertinent, but not problematic, because some lawyers will work on contingency. I think this is what it's called, basically, whereby if you win, then we'll just take a huger chunk of the proceeds from the lawsuit. But if you lose, you don't have to pay anything. And by it probably being R. Kelly, and probably by them kind of like playing all the angles, they probably figure it was a good risk. I don't think she paid those.
At that time, you go on to show motive, which is right here in the permitted uses of it. So let's talk about the be admissible for another purpose, such as proving.
Hold on a second. Can you hover the mouse over or scroll down where you at?
Okay. Permitted uses right here.
All right, scroll down, because I got something in the way of the screen. Okay, perfect. All right, permitted. What's the prohibited uses? I want to read that first. Evidence of a crime, wrong, or other acts is not admissible to prove, and that's what I'm saying. So, first off, let me just tell you up front, everything that you said in that video, I agree with 100%. But this is a cold game. This is a cold game. You can't even talk about all that stuff, because they're going to try to bar you from even bringing all that stuff up. So you're looking at, and I haven't seen that video in a while, but when I found this Rule 404 in Illinois, basically I realized that although you know the person is trash and you know that they conniving, but you can probably have people to basically testify on all the stuff that person's done, but you can't even get that in the courtroom because of this rule. So when you look at prohibited uses, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. Right? So the only evidence that you're going to be able to bring in is the prohibited evidence. The evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of a mistake, or lack of accident on request by the defendant in the criminal case, right? So you can't even get all the evidence in. I think the only evidence that R. Kelly may be able to get in is the recordings or other people talking about how she loved, giving, I'm not going to say that word on here because I want to keep it clean, but how she loved giving, what. But all the other stuff, I don't know if they'll be able to bring it in.
Fellatio is the word that you want to use.
Okay, because I don't want to get that flag.
Right. You saying you don't want to say sucking dick, but it's fellatio.
So you gonna lose monetization on your video, dog.
This opinion, bro. We don't worry about that type of shit.
The computer gonna pick you up, dog.
We don't worry about that type of shit over here, man. The people fuck with me, dog. They gonna cash at me whatever I'm missing. And
I ain't getting no cash.
Well, that's because nigga, you don't ever show your face, nigga. You know what I'm saying? So, we know you could be Levi in this motherfucker. Dog. We got Levi on the phone. Levi on the phone. So let's bring it back. All right. So I'm gonna pivot from right here. We're gonna go over to the Illinois statute, right?
Let's go to Illinois. Now, Illinois really gonna stop all that. So Illinois only limits certain amount of information in the court.
Okay, right. So let's read through this. So first off, We got to go all the way through this. We got to go through.
Can you enlarge? Because I don't think they're gonna be. You know what? Let me find you live because I actually
404 and 405 are the same. 404. Damn. So 404 and 405 are basically the same statute. So I'm reading it. So evidence of a specific person's character or trait of character is not admissible for the purposes of proving action conformity therewithin on a particular occasion, except the character accused in a criminal case, evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same. So when you go to that, then you have to come out. You have to go out of that, right? And then you have to find out what specifically mean by pertinent.
Right.
Okay. Pertinent is basically pertinent and good character or basically interchangeable terms, right?
No, pertinent. No. Pertinent means relevant or applicable to a particular matter or opposite. I don't even know what that word means, but particular. Pertinent, relevant, or applicable to a particular matter. So basically, you're only going to be able. So when they try to cross-examine with Lanita Carter, they're only really supposed to bring up stuff as it relates to the issue at hand, right? They can't get her to talk about her past relationships unless her past relationships involve fellatio. You see what I'm saying?
As a defense prosecutor, as a defense counselor, I'm going to argue that you have went back 20 years to bring this issue up against my client. I'm bringing all of it up. And then I'm arguing the appellate court rights because I'm telling the judge if she don't allow this, then I'm immediately going to exercise my ability to file an appeal. See, this is the difference between. No, I won't. This is the difference between like arguing law and looking up the definitions.
You'll lose, baby. You'll lose.
I guarantee you, I won't. Because you still have to argue in the appellate court. It's right here. This is the reason why it's called a defense argument. You're arguing something, right? It says evidence of a person's character or trait of character is not admissible for the purposes of proving action in conformity therewithin on a particular occasion, except the character accused in a criminal case. Evidence of a pertinent trait of character offered by an accused or by the prosecution to rebut the same. That means that you, as the defense counsel, have the right to bring stuff into evidence. But the government reserves a right to rebut it. That's right. What that's saying.
Oh, of course. If they don't catch it, if they don't object to it, so they're basically going to object to it. So when you go down that line of questioning, oh well, tell me about your ex-boyfriend or your ex-husband. Objection. You're going to get an objection right away. Right. And then it's going to be up for I believe you're going to get an objection right away. And then it's going to be up for the judge to basically decide whether or not it's, a legitimate objection. She's going to either sustain it or overrule it. Let me see. I was actually trying to go to Justia Law and try to get some case law. But basically, from my understanding of this statute, and like I said, I'm not disagreeing with the content of the video because the content of the video was extremely good, but
I disagree with you, man. I'm just gonna tell you that off top. You offer me bullshit arguments, man. For real. I'm saying you offer me bullshit arguments, man.
No,
these are bullshit arguments, bro. I'm telling you when it's pertinent to the situation at hand. If she was going through
I agree with that.
It's pertinent to mention that I'm going through a divorce with a legal aid clinic, and then now I hop on an attorney that's making several millions of dollars per year. Yes, it is because you have to prove motive. You still have to prove motive. However you want to twist this around, you can offer me 50 arguments. I'm gonna offer you 50 goddamn arguments back the same way. And we
so you're saying that it's pertinent because you're trying to prove motive in the sense that she's trying to run game. That's why you said.
I'm first off, let's take a step back. We are arguing a criminal case. Would you agree?
For sure. That we're looking at criminal statute. Okay.
What's the burden of proof?
The burden of proof is for the prosecutor.
No, what is the burden of proof?
Like, what do you mean? I'm not understanding what you mean. What your question is?
You got 5 burdens of proof. You got reasonable.
Oh, you're gonna have to educate me, man. You're gonna have to educate me.
Right. So we have to prove beyond a reasonable doubt.
Okay.
It is something to doubt right here when a person is going through something. And one, let's get past 2003. Let's go to 2009.
Okay.
She goes back and she says, "Oh, he made a song called Hair Braider about me." You can go to the patent office, the trademark and patent office right now, and look up the name Lanita Carter.
Right.
And see that she has a copyright or a trade design on a specific braiding pattern. And then what the evidence is used, because what they have done is they have gone out into the media and found this guy to be publicly harassed this guy in Surviving R. Kelly 1, Surviving R. Kelly 2. She went to the national news media with her lawyer, Michael Apinun8d, who was convicted. She came out after Michael Apinun8d was convicted. The fact of who her personal conduct lawyer was, that draws a huge red flag, but I'll continue or whatever. So with us having to go beyond a reasonable doubt, well, it said that he spit on you 6 times in one instance, then 7 times in another instance. That's reasonable doubt.
Right. Oh, for sure.
Under reasonable doubt, then you go on, you have a foreclosure in 2007 and 2008, and then you not only do you have a foreclosure in 2007, but your son is in JROTC, and you put in arguments saying that I got a military son in the house in order to stop your foreclosure, and then you stop the foreclosure there and get foreclosed on again. Then 8 months later, you pop up and you find an opportunity to sue R. Kelly again over something that you don't have a copyright or trademark.
I think I see where you're going. You're saying it's pertinent because she was in the situation where she needed money and she was constantly running all these scams to basically get money with the military son and, all the other stuff. Is that what you're saying?
Right. Yeah. Because listen, when you are saying pertinent to the incidents in this case,
right.
If we take out, we just got to go to the 2 main years in question here, 2003 and 2004, right? Because I had enough evidence to do a second video on Lanita, but I stopped right there because she's not credible based off of Cook County records alone.
Right.
So
I think that's a better argument. Your argument is probably to challenge her credibility. I can't even say that.
And you have to remember that this very court that is bringing this case now chose not to bring the case 17 years ago when it happened.
Right.
That's pertinent. That's huge.
Right. That is. But I just don't know that all that history, her personal history, is going to be pertinent because we're talking specifically about the criminal charges against him for, sexual abuse. So one of the things they probably would do, they're just going to object and say, how is any of this relevant to the sexual abuse? That's what I think is going to happen.
Again, she went before a grand jury. A grand jury chose not to convict.
Right.
Lanita Carter in and of herself is not strong enough to convict. They had to go and get 4 other bitches
to for sure.
give validity to Lanita Carter. Lanita Carter has made 2 conflicting statements. So you have a for-profit motive in 2003 because it's pertinent if we bring in all of her, everything that I brought up was in relation to things that she said.
I
So
know, but, but
but when she's talking about this case, bro,
right.
let me get the point. I'm gonna give you the floor. When she's talking about this case, and she said, "Well, I wasn't getting paid that much, but I was bringing her 3 times a week, and I was getting $100. And after I paid $20 a piece for my 3 kids, and I did a $20 taxi ride, I wasn't even getting no money. Money is an issue."
Right.
So you have to show the history of money problems at that point.
Right. But
So that's how it's pertinent, man. It's
here's the
pertinent.
problem with all that. Here's the one problem, and probably the one reason they're going to say it's not pertinent is because everything you said is correct, but those are arguments that could have been made in the the civil suit against R. Kelly. We're talking about the criminal suit. And because we're talking about the criminal suit, her character is going to be limited, or questions of a character, I believe, they're going to object, and they're going to try to limit. And believe me, I'm not trying to advocate for Lanita Carter. I read this law because I was looking up something else, and I thought about it. And basically, the arguments or the questioning is going to be limited to character evidence as it regards to her sexuality.
So let's look at the case
Anything
law.
above and beyond that, I don't think it's going to be admissible because it's not pertinent.
So let's go into the case law.
Okay. What you using, Justia?
No, we going into, this is Illinois.gov public public. Oh, all right, let's go. Let's start up here. Let's see which case laws apply. Aggravated sexual assault is committed when one commits criminal sexual assault and the one statutorily delineated aggravating circumstances exist during the commission of the offense, including that the accused caused bodily harm. Because of the statutory offense of aggravated criminal sexual assault does not prescribe a mental state, the mental state of intent and knowledge of recklessness is implied. If during the course of sexual assault the defendant caused bodily harm to the victim, the state need not prove that such harm was inflicted knowingly or intentionally to convict a defendant of aggravated criminal sexual assault. An inadvertent or accidental infliction of simple bodily harm is sufficient. The court correctly convicted defendant of an attempt aggravated criminal sexual assault where the state proved that the defendant intended to commit a sexual assault and inflicted bodily harm on the victim, even if the state were required to prove that the defendant intended to. So that's about bodily harm.
Right.
That is not what they're alleging. The defendant was charged with aggravated criminal sexual assault.
You probably need to search on character evidence or a permissible.
Oh, we on sexual assault, right?
Right. I mean, we're on sexual assault, but the context of this conversation is what's admissible and not admissible in the sense of character evidence.
Okay, let's see here.
Because this is just going to give us line after line of sexual assault case law.
Taking off. Okay. So let's see here.
Character evidence. Or you can actually search for the rule.
Okay, let's see here.
What is it?
Character, Illinois.
Character evidence.
Character evidence.
Let me see something. Let me see
So
somebody.
basically, we have to go through. We have to go all the way through this. I mean,
Yeah,
this really
this takes time.
this really should be kind of a video series or
Yeah,
what have you, because the reality of it is just that
but you
just
understand what I'm trying to say.
no.
I think
Well,
there's a risk
it's
that some of the stuff wouldn't be admitted in court. Your
all
video,
of it. All of it reasonably would be admitted into court because again, this is their stuff. The prosecution bought this case,
I
and
got.
so that's because listen, right? The last part of when you get ready to go to criminal court, right? When you get ready to go to criminal court, then you have the prosecution has to turn over discovery.
Right.
They have to turn over discovery. And they have to give you a full character profile of who they're calling as a witness. That's within the Brady Doctrine. That's just within the Brady Doctrine alone that they have to go to who it is that they calling as a defendant. So within the Brady Doctrine, then that has to be disclosed during the
I got
discovery
something
process.
for you. I got something for you.
Yeah, go ahead.
Let me share my screen.
Go ahead. Let me take this shit off. Go ahead.
Okay. So this is. Let me know when you can see it.
Let's see here. Okay, got you.
All right. So this is a case, Illinois Supreme Court, the people of the state of Illinois versus Willie E. Enoch. And when you scroll down, they're talking about character evidence, and it basically. And I didn't read this whole thing. And you're right. This takes a lot of time and effort to kind of research so we can have an intelligent conversation on it. But anyway, it says, following the suppression hearing, the state made an offer of proof asking that evidence of other crimes unrelated to the murder of Kay Burns be admitted to show the defendant had the intent and design to commit rape against the victim. Over defense's objections, the court admitted evidence concerning the two prior incidents. As to the first, Luella Burnside testified that on March 6, 1983, the defendant raped her. She said that having locked herself out of the apartment at about 4 a.m., she was walking in her neighborhood looking for her husband who had her keys. When she met the defendant, he pulled a knife and stabbed her in the back. Damn, this dude was vicious if it's true. Pulled her into a garage, threatened to cut her throat, told her to remove her cloths, and then raped her. After raping her, he told her he would tie her hands being behind her back loosely so that she could escape after a few minutes. So we don't really need to read all of that, but basically what I'm trying to highlight is that they had to petition the court. They had to ask the court to basically submit that evidence into court. That's all I'm trying to say. And this was evidence of other rapes, asking that evidence of other crimes unrelated to the murder of Kay Burns be admitted to show evidence. So the only thing I'm trying to point out is that you just can't bring that evidence into court. That's all I'm trying to point out. You have to try to get it into court some type of way. My argument is that they're going to try to block that evidence from being brought into court. Like if it doesn't, I think what's going to happen is that when R. Kelly lawyers go to question Lanita Carter, they're going to try to object to anything that has to do with her past.
Okay, so then I got something for you right here.
Go ahead.
Okay, so let me blow this shit up. Give me 1 second. All right, so when we go to the People versus Freeman, right? It says the rape shield statute, Illinois, 115.7 prohibits admission of evidence of the prior sexual activity or reputation of the victim of a sexual assault with 2 limited exceptions.
Hold on a second. I lost my train of thought. I got distracted. Start over again. I'm sorry.
The rape shield statute, Illinois criminal statute 115-7 prohibits admission of evidence of the prior sexual activity or reputation of the victim of a sexual assault with two limited exceptions. This is to prevent harassment and abuse of a sexual assault victims where their sexual history is irrelevant to whether they consented to a sexual contact with the accused. A statement of alleged victim of sexual assault to an ER physician that she had not had sex did not defeat the purpose of the rape shield. It did not defeat the purpose of the rape shield statute. It was properly admitted as an exception to the hearsay rule as a statement made by a sexual assault victim to medical personnel for the purposes of diagnosis and treatment. So here you see that certain documents were permitted into evidence. And
bro, no, that ain't how that reads. That, bro, look. Well, first off, this is not character evidence. I just want to point that out. This is not character evidence. This is scroll up a little bit. This is something to do with some type of rape shield.
This is all sexual assault.
Rape shield, but it's not. We're not. It's not character evidence.
We are arguing sexual assault. So the sexual assault case law,
character evidence,
and you're talking about first off, the thing was a pertinent trait.
Right.
Pertinent means pertaining. The key word of pertinent is to pertain. How does it pertain to this case? This pertains to the case because he's being charged with sexual assault.
Prohibits admission of evidence of the prior sexual assault, sexual activity, or reputation of the victim. Yeah, so this actually proves my point, right? Because the rape shield statute prohibits admission of evidence of prior sexual activity or reputation of the victim. So this is actually worse than what I thought. Hold on a second. Right, but hold on a second. No, I get that.
You didn't complete the sentence.
Okay, sure. Let me read it over. Let me read it over. The rape shield statute, 725 Illinois Civil Code and Procedure, 115.7 prohibits admissions of evidence of prior sexual activity or reputation. So this is character evidence of the victim of a sexual assault with two limited exceptions, right? So basically everything is prohibited except for two situations. And then it just basically says its purpose is to prevent harassment and abuse of sexual assault victims where their sexual history is irrelevant to whether they consented to sexual contact with the accused. The statement of the alleged victim of a sexual assault to an ER that she had not had sex before did not defeat the purpose. Yeah, it doesn't tell us what those two exceptions are, though. It doesn't.
It says its purpose is to prevent prevent harassment and abuse of a sexual assault victims to where their sexual history is irrelevant to whether or not they consider with the accused. Okay, so to prevent harassment, to prevent harassment, right? That's one, right?
Right.
Then a statement, a hearsay statement, is where it's an exception to the hearsay rule. So if I'm arguing my stuff, it's just hearsay by the state of Illinois. That's what I'm going to argue. It's hearsay. Again, you can't. It comes down to the way that your lawyer argues the case.
For sure.
And she is a hostile witness.
You know what? I'll agree to this. I think if I'm not a lawyer, of course, neither of us are lawyers, but if I was a lawyer, I wouldn't ask her. I would try to get the information on the record indirectly. Like I would ask questions that were pertinent, but try to ask in a way to get her to talk about her history and all this stuff. But I don't think that you can directly ask her about, her courting, her evictions from her home or foreclosures, because none of that is going to be pertinent.
Now I want to show you something, right?
I found something else, but I'll let you go first.
Okay, so right here, right? I want to show you something. This is very key, right? All right, do you see this right here?
I can't see it now. Okay, go ahead. Yeah.
You see where that's highlighted, right?
Right, that's the Illinois statute.
Okay, so the basis of your argument is whether or not it would be permitted, right?
Admissible, right.
Right, so let's write this down. So 725 Illinois Criminal Statute 5115-13. Right now, we're gonna go right back for a second. Right, just give me a few minutes. Right. All right. Now, all right. Now it says the evidence of a person of the or trait is not admissible for the purpose of proving action or conformity there within a particular case, except in a criminal case where evidence of a pertinent character is offered. Right. In a criminal case,
Of a pertinent trait of a character is offered. Go ahead.
All right, cool. But of subject to the limitations imposed by 115 of the criminal code procedures, and then it's a 115-7. And so when we arguing that or whatever, then this tells you that everything in 115-7 is an exception.
Okay, let's see 115-7. Did you bring that up?
115-7. Okay, let's see here. Illinois. I'm sorry. Okay. Okay. Let me see if I can find a better viewpoint of it, because I hate the way the Illinois write their damn case laws. Shit.
Let's see if I can find it.
Yeah. Okay. So. 15. Okay. Okay.
And prosecution for predatory. So that's basically predatory criminal sexual assault of a child.
Let's see here.
That's not going to apply to Lanita Carter. So that's what it is. It's a predatory sexual assault. So small.
To be held in camera in order to impeach your witness. Okay. Less than 45 time and place and combination.
This is not going to apply because it's not going to apply to Lanita Carter because it's because this is not going to apply to Lanita Carter because it's criminal sexual assault of a child. So when it comes down to Lanita Carter, it's not going to apply because Lanita Carter is not a child. So there's no sense of us reviewing that.
Give me 1 second. Okay, yes it is. Because if you come all the way down right here, it says the court shall not admit evidence under this section unless it determines in a hearing that the evidence is relevant to the probable value of evidence and outweighs the danger of unfair prejudice.
Right, but the problem, but hold on a second. But it's not. Look, can you read the top part of it? The very top.
Yeah, it says which part? Which part?
115-7A.
In process. All right. Fuck. I gotta blow this shit up.
Yeah, I know it's small. You're gonna go
this
blind.
Is why I don't. I hate this shit, yo. I hate.
Don't go too far. There you go.
In prosecutions for predatory criminal sexual assault of a child, aggravated criminal sexual assault, aggravated criminal sexual abuse, or the criminal transmission of HIV, and in prosecution of battery, aggravated battery, and when the commission of the defense involves sexual penetration or sexual conduct as defined in section 11.
You're right. It might apply.
Yeah, man.
It might apply.
I mean, come on, man. I'm cold with this shit, dog. I'm cold with this shit. I'm cold. Dude, the top three lawyers in the country said I'm that nigga, man. I'm trying to tell you around this motherfucker, man.
All right, so go back to what you're saying. So
Can I get my
this proves my point, though. The
It
court
don't
shall.
prove your point.
It
You're trying to
does.
finish the
Go ahead and read it.
point.
Just go ahead and
This
read it.
says that the evidence is relevant of the probative value. It outweighs the danger.
Read it again. Read it again. No. Go back. Go
I'm
back.
going down here, man.
Right.
See,
The
this
court
is
shall not admit evidence. Hold on a second.
Bro, you good at what you do, but you
Right.
don't have an understanding of what you do, man. You don't have an understanding of what you just reading this shit verbatim, but you don't have an understanding of the application of this shit, man.
Listen.
I'm a defense lawyer. So all I need to do is find the slightest crack in the law, and I'm gonna rip that shit all the way apart. This right here.
Let me read this to you. The court shall not admit evidence under this section unless. So let's stop right there. So the court. Hold on a second. The court.
Go ahead.
The court decides.
I want you to read through all of it.
I will. But we need to stop right here. The court decides what evidence is going to be admitted and what's not going to be admitted. Am I right?
Yeah.
Okay. So what I'm trying to point out to you is that before anything can be discussed, a court is basically going to have to, the judge is going to decide what you can bring in that court and what you can't. And if they try to basically bring in Lanita Carter's history into court that doesn't pertain to the criminal sexual assault, I believe the court is not going to admit it, right? And if the defense lawyers for R. Kelly tries to question Lanita Carter about her history that doesn't have anything to do with this criminal sexual assault, I believe that the prosecutors are going to object. That's all I'm saying.
Do you know that discovery has not been turned over in this case yet, man?
Oh, I didn't know that. I figured they would have turned that over a long time. You can't have no case without.
Man, come on, man.
You can't have no case.
You arguing with me about this shit you ain't even studied, man. You know that you ain't know that the damn discovery ain't been turned over.
Hold on a second. I'm gonna tell you right now. I don't keep up with all the details. I know. Actually, when it comes down to like one of the federal cases, I think the federal case in New York, the discovery has been turned over because I actually did a video on that. But yeah, I don't keep up with everything that's going on. But you can't have a trial until that happens. I know they turned over
back to a Brady rule violation, of which I already said that once you turn over the discovery and the background checks, which is probably the last thing that happens in the discovery process, then this is going to be in the court records. It has to be in the court records. That has to be in the court records. A background check, man, has to be in the court record.
Actually, hold on a second. I'm still reading the statute. I don't think the background of an individual is going to be pertinent. Such offer of proof shall include reasonable specific information as a date, unless the court finds that the reasonable.
I never argued the background. If you notice, I didn't really argue. I said I put the dick sucking video in there. I said
that can be admitted. That's one thing that's going to be admitted.
I wouldn't argue that because you need something for the appeals court. You need something for appellate court. So you don't argue every single point in there. You leave something in that you did not argue so that if the defendant loses, then on appeals, you can argue I had ineffective counsel. It's called legal strategy, man. You don't argue every single point. So even when we read right here, it says no evidence should be admitted under this section shall be introduced. Right. No evidence admissible under this section shall be introduced unless ruled admissible by the trial judge after an offer of proof has been made at a hearing to be held in camera in order to determine the defense has evidence to impeach the witness in the event that prior sexual activity with the defendant is denied. So you can offer it to impeach the witness. So this is basically saying throw these motherfuckers off the stand.
So I'll agree with you on that, but what I'm trying to basically point out, I mean, it says it right there, so there's really nothing for me to agree. But what I'm trying to point out is that you have to get a judge to sign off on that. You just can't go into court and say, yeah, we're going to talk about Lenita Carter's eviction. We're going to talk about, her past boyfriends. A judge has to agree with that. And I don't think a judge is going to agree with that. The judge is probably going to be like, look, you need to just limit the conversation or the questioning to the incident at hand. That's what I think is going to happen. I don't know.
So do you think that her settlements are going to be brought up in court?
I think that if they do bring up, hold on a second. It depends on what context.
No, I'm just asking you a simple yes or no question.
Ask the question again. Ask the question again.
Do you think that her two settlements she had with R. Kelly are going to be brought up in court? Yes, they will be. They will be. Okay, then
that would be perfect.
Her whole financial history has to be brought up then.
Interesting. Why do you say that?
Because what they're going to do is first off, you sign a non-disclosure when you took a settlement, right?
Right.
You took a monetary settlement, right?
Right.
Basically for compensatory damages, right? So that basically means that you were so hurt that $650,000 healed your pain, right? And then another $100,000 healed your pain.
Right.
So who's to say that you're not here right now for another monetary settlement to heal your pain, being that you already went to NBC, CBS, CNN, and did a sit-down interview with what's the girl named Jerika Duncan or whatever her name was. You got paid for that.
Right. That's a good argument. That's a good argument.
So,
that is a good argument.
Bro.
That's a good argument. That's a good argument. Because you basically saying she's hopping on the bandwagon to get paid.
Yeah.
Yeah,
it's obvious. Dude, all I need is like this. Okay? I need this much skin. I'm a slick motherfucker like Michael Apinun8d. Even if Kales did this shit, if I went to court, I would make them walk up out of there and doubt everything. I don't need to discredit everything. The matter is beyond a reasonable doubt.
Right.
Beyond a reasonable doubt. If I give you an inkling of doubt, you cannot convict my client. That's all. Right. All that I'm gonna say. And I'm a moonwalk out that bitch.
Right.
I'm gonna tell Kale get on top of your Sprinter with some pajamas on and start moonwalking in that motherfucker, man.
No doubt. Well, hey man, look, I need to get something to eat, man, before I go to bed. I really shouldn't be eating and going to bed. But look, I enjoyed the live. We got to do this again. I'm still not 100. It's a good argument, but I'm not sure if it's allowed. I'm going to do some more homework, and if I, find that anything out of the homework that I do, then we'll have another session on this. Otherwise, we'll have another session on something else.
Next time we have a session, though, you gotta send me what we're gonna be arguing about, so I can prepare.
For sure.
I want you to tell the people that all of this shit is coming off the top of my head, right? And you hit me up at the last minute for this shit,
right?
But
right.
Is coming off the top of my head, right?
Oh, for sure, it's coming off the top of my head.
You were prepared.
No, I wasn't prepared. I told you that I watched your video and I thought the video was cold. And I was like, damn, this is a good ass video. I mean, like, he made some really good points. And then when I saw you come onto my channel, I was like, oh, well, this is what I want to talk about. Because I think when you came on my channel, you was like, we need to do a video. I don't even know what you commented on, but you was like, we need to have a live session on this. I was like, cool. But what I really want to talk about is this Lenita Carter, because after watching your video, I think maybe 2 or 3 weeks later, I ended up coming across the character evidence. So I'm not 100% sure that you're going to be able to talk about the settlements. And even if you are able to talk about the settlements in the trial, I'm not 100% sure that you're going to be able to talk about her financial history and all that other stuff, because it's really not relevant to the criminal sexual assault. But you got a good argument there. No, I'm agreeing with you. You got a good argument.
No,
It's a money
I'm
grab.
saying on this, for the purposes of this, you are arguing kind of as the prosecution, right?
No, you know what? To be honest with you, like I said, I don't support Lanita Carter, but I just got stumbled after watching your video and then coming across the character evidence. And, so that's why I wanted to, talk about this. That's all.
But what I'm saying is that your point would be something the prosecution would argue, right?
I believe I'm not arguing as a prosecutor, but I believe the prosecutor is going to argue this.
So to that argument, see, the prosecution basically shot themselves in the foot, because anything that they bring up, any type of argument that they want to use, the way that I argued it right there is that one of your argument points, you're going to have to let in other things to basically rebut against your argument point.
Right.
So if you argue that, well, he should have did it because look at these settlements. Well, then now we got to bring in your financial history because you bought up money.
Right.
If you bring it up, well, he has a history of sexual assault. Let's look at your sexual history.
So how do you think? So let me ask you a question, not to interrupt you. How do you think the settlements are going to actually be admitted into the court for the
listen, I'm going to win either way. So if you bring the settlements in, I'm going to destroy the settlements. If you leave the settlements out, that's one less thing I got to worry about. I don't see where I'm.
If they leave the settlements out, then you don't get the character evidence.
How?
Because basically the argument you just made is that you get the character evidence by way of the settlements, because basically the point is going to come up that R. Kelly paid her out, and she only is doing this now because you can see from her history that she was on some money grab type stuff, and she was basically doing all this bogus stuff to get money, and this is just another way for her to get money. But if the question of the settlements never come into play, then how do you get the character evidence in?
How do you get the character evidence in? Well,
because
you have to argue the nature of the crime, right? Because as we know it right now, Lanita is only a part of the Chicago state case.
But hold on a second. So, not to keep interrupting you, but I guess what I'm saying is that the nature of the case is criminal sexual assault. You don't get the foreclosures into the case. You don't get the fraud where she claimed her son was a military or a part of the military or something like that to delay the for. You don't get all that juicy evidence in the case without the settlement.
Well, how did the case come about? How did she get admitted into the case?
Because she claimed R. Kelly criminally sexually assaulted her.
But it was thrown out before the grand jury. So how did we get here today?
I don't know. That's a question for the prosecution.
My point exactly.
Right.
If you can't explain how we got here today, then I have to grasp at straws to find out why we're here. So if we're going all the way back to 2003, right?
Right.
Because this is not a trial happening in 2005. This is a trial happening in 2020, and at this point, it's going to happen in 2021. So at that point, it's going to be 18 years that pass. So you show up with a lawyer who's a fraud.
Right.
I mean, what's your motive? You were paid twice. What's your motivation to be here?
Right. Exactly.
Exactly. And then you ask the judge. You ask the judge for permission to treat her as a hostile witness.
Well, here's the thing. Here's the other thing that I just want to make you aware of. So it's the prosecution's choice to bring this back up again. We don't know that Lanita Carter actually called it in to say, hey, he sexually assaulted me. I want him to be punished for the sexual assault. As you know, they already had this case in 2003, and they decided not to. When was it?
Hold on. Say what you just said over again, bro. You talk real fast.
Okay, when did they bring up this case against Lanita? When did Lanita Carter first bring this case up?
She first went to the grand jury back in 2003.
Right. So
September 19, 2003.
Right. So what I'm trying to say is that we don't know that it was Lanita Carter's choice to be put in this case again.
Yes, we do.
No, we don't. We don't.
We do.
Because
yes, we do. Yes, we do.
This is why I'm saying this. Listen, just hear me out.
You ain't did no research on your own people, man. Lanita Carter went on national television and she said that when I heard the prosecution put out a call for people to be in, for people to step up if they've been abused by R. Kelly, she said I could not miss this chance.
Really? Okay, all right, correct. Hey, I stand corrected. If she said that, I stand corrected. But my thinking was this: we don't know that Lanita Carter actually had a choice, but if she said that, then it was her choice. Because you know what I was trying to say? I was trying to say the prosecutor can decide whether or not they want to bring up this old stuff or not, because they already had the testimony and they already had all the alleged evidence. They could decide whether or not they want to bring it up. But if you're saying she said that, I'm just going to take your word for it.
Don't take my word for it. I'm going to show you the goddamn TV interview. You know what I'm saying?
No, we ain't got to do that. I mean, if she said it, she said it. I mean, I can go and look at it myself. I believe you. But hey, look, man, I'm finna get off and go and get something to eat. I enjoyed this conversation. We definitely have to do it again. If not on Lanita Carter, we got to do it on something else. As you know, the hottest thing out now is the one guy that was shot in Georgia. Yeah, have you done any research on that?
Nah, but I mean, shit, man, it's a defense argument, bro. We can argue opposite angles of that.
Right.
You know, we can argue.
All right, so let's do this. So the next time we hook up, we're going to talk about that, because then we have to look at case law on. So the issue at hand is the law at hand is probably the core law at hand is probably going to be citizens arrests. So, and there's a statute for citizens arrest, and then there's case law on citizens arrest. So that's what we're going to be.
I'm telling you, dog, listen. When we argue with, I got a whole clique of people called the boots on the ground, bro. We got a position in the boots on the ground. That's for you.
So let me ask you a question. Do you think
I'm gonna let you be my co-counsel, all right? I'm gonna let you be my co-counsel. You know what I mean?
No doubt.
We got a position just for you. You feel me? You might as well go ahead and join the boots on the ground today. You feel me? You can go ahead and join me. And listen, I'm gonna make you a cold lawyer too.
Well, I enjoyed the conversation, and
ones like this. You know what I mean?
No doubt.
You know, you're gonna be having a bad bitches in the strip club. You know, you're gonna be sending a cease and desist out next week, man.
You're a fool, boy.
I'm telling you, man.
You're a fool.
Listen, you tell me whatever case you want to argue, and I guarantee you, I'm gonna come through, man. I guarantee you.
All right. Well, like I said, the next live session is either going to be a continuation of admissible character evidence, or it's going to be the situation in Georgia. Oh, or it could be, I just did a video series on the Savages, because you know they actually released a video of R. Kelly's previous living quarters, and one of the questions that pops up is, are they liable for invasion of privacy, false light? And then someone else pointed something out to me called droxing. You know,
that's criminal trespassing, man.
I don't think trespassing is going to apply, and here's why. Because more than likely, Azriel's name was on the visitors list.
It don't matter.
Or either it was on the visitors list, or she's a she lives there. Her name is basically on the list as a resident, it's not the visitors list. And because her name was on the visitors list, she was allowed to go up. Another scenario could be that they said, well, hey, I left some things up there. Azriel went there and said, I left some things up there. I need to go back up there and get the rest of my stuff. And
you understand that they got access control at the Trump Tower, right? Yeah, you know, somebody had to let them up there, and she had left. She left. if what you were showing off from inside the house was all Robert's possessions and Robert's belongings, it's a thing. It's a statute under the law called knowing or reasonably should have known.
Oh, for
He
sure.
reasonably
Yeah.
should have
For
known that was that was his house.
Well,
301.
she knew.
West Wabash Street or Road. I mean, you from Chicago.
Right.
You know, everybody knew that Robert stayed at the Trump Tower. So
Well, she knew it because she used to live with him there. So she knew.
Yeah.
She knew.
Again,
but the problem is if they have authorization to go up there, trespassing doesn't apply. Trespassing only applies when you don't have authorization.
Now listen, you have the rules of privacy come in two places, right? If you in public, but in somebody's private dwelling quarters, then they have a reasonable expectation of privacy. Reasonable expectation of privacy.
For sure.
So they breach his reasonable expectation of privacy.
Well, I tell you what. It seems like you like this one. Let's not waste this conversation in this live. We already had a good live. I'm finna go and get something to eat. I'm finna, set up camp. So I'll reach out and schedule another live with you, and this will be the topic if you choose so. But it seems like you like this topic pretty good.
I mean, look, boy. I before you leave, I just want to show you this little video that I did on Tim Savage. My belief, you know what I'm saying? That they were trying to send her in there. You know what I'm saying? I got this. I got the whole girls come in. Listen, man. Listen, I got the whole Savage family. I got the whole Savage family. It's a 2-part series.
Okay.
2-part series.
Okay.
It's a 2-part series. You know what I'm saying? So listen,
I'll check it out.
I'll fuck you up on Tim Savage too, man. Listen, you might as well just go ahead become part of the boots on the ground pool. You know what I'm saying? We need a non-lawyer. You know what I mean?
I was going to ask you to be a non-lawyer. What you talking about?
Listen, bro, I can't be a non-lawyer. Alan Dershowitz already told me I am a lawyer.
Oh man.
Marlena right here can testify to it.
Right.
If you go on Dr. Rogers live from yesterday, Lisa and Kelly both told you that the lawyers and co-sign me, man. You know what I'm saying? You know what I'm saying? This is just keeping it real with you. You know, listen, it's a spot over at Opinionated right here. The Opinionated non-lawyer co-counsel, and we're gonna bring the Boski on as a third legal team, man. Third legal team member. Now, of course, I gotta be lead. Right. I gotta be lead. You know what I mean? But you can be a co-lead.
Oh,
you know
I gotta be a co-lead. I gotta be a co-lead.
I got to be the lead. You know what I mean? But you too nice. Fuck that. You gotta take the mask off in this month.
No, I gotta keep the mask on, man. The mask is what keeps me safe.
That's what I'm saying. We can't see your face, so that's why I come.
No, I'm never showing my face. I have a life, man. I have a life.
I got a life too.
Well, let me say this. That was disrespectful the way I said it, but I like to keep my life private and personal. When I step out my door, I want to focus on the issues. There's two reasons. I want to keep my life private and personal, and then also I want to focus on the subject matter. I don't want the subject matter to be about me as a person. I want the subject matter to be about whatever it is at that time. But hey, man, I got to get off this live, man. I got to get off. But look, so the next time we hook up, we're going to talk about the invasion of the potential lawsuits against the Savages, whether it's trespassing or invasion of privacy.
We got to set a time, bro. We got to set a time.
I'll reach out to you via email.
No, it ain't gonna work. That one ain't gonna work, bro. We gotta set a time like now, so that I ain't gonna be able to order that last minute.
What's the rest of your week looking like?
I
would prefer Friday. I would prefer Friday night or
Friday at what time?
7.
7 7 Central Standard Time. Let's make it 8. Let's make it 8.
It's on 8
All
o'clock.
right.
And I'll email you to work out the rest of the logistics, what we're going to talk about, so on and so forth.
All right, bet.
All right, man. I enjoyed the session, and I'll let you next this Friday.
Definitely. Appreciate you for stopping through.
All right, later.